We are live.
Okay, excellent. Welcome to the work group on use of force, duty to intervene, and whistleblower protection. So today we're going to try to keep this limited because it's late on a Friday afternoon. So the way we're going to structure this is that committee counsel Jamie Lancaster has a presentation that has glommed together the proposals that deal with those three subject matter into a PowerPoint presentation. He'll do a kind of a wave top presentation. We'll walk through together as a committee, hopefully identify some areas of concern or areas that folks would like to discuss further. This will give members an opportunity to draft amendments or suggestions for consolidation as we go forward. And then we'll have just a little bit of time to discuss as a committee. And just like last time, we will have members of kind of the experts from around the state that were invited and folks that have just signed up to participate in this process in the gallery. And we'll be able to solicit their expertise if needed. But unlike last session, I think this should be more of a committee-driven process, a committee discussion. And so with that, Jamie, Mr. Lancaster, I'll turn it over to you for your presentation. Again, we're just going to hit the kind of the 30,000 foot level wave tops for the three pieces of legislation. I think that Senator Carter, Senator Sidnor, and Senator West, I think those sponsors are the bills that we're using as a basis for discussion today. So with that, Jamie, I'll turn it over to you and we can start off with our presentation. Also, as a parenthetical, I'd really like to keep this, I know it's Friday, again, I'll just foot stomp this again, we keep this conversation streamlined so we can make sure that we get out of here at a decent hour. Jamie, you're up.
Thank you, Senator. Let me get the presentation up. I'll try and be brief with it. Let's see. So are you able to see my screen?
We are. It's great. Just full screen presentation mode. It's good. Thank you.
So starting off with Senator Carter's Senate Bill 626, which is law enforcement officers' use of force. The bill has several provisions. Primarily, it deals with the use of force and provides several authorizations and prohibitions. It provides that a law enforcement officer is authorized to use force only when, first, it is necessary force as defined under the bill, when reasonable alternatives, and that term is also defined in the bill, have been exhausted. And then also until its use has been until its use has accomplished a legitimate law enforcement objective. The law enforcement officer needs to immediately modulate the use of force as a threat diminishes and cease the use of force as soon as the person against whom force is used is under the officer's control, no longer poses an imminent threat as defined under the bill, or the officer determines that force will no longer accomplish a legitimate law enforcement objective. If the use of force against a person results in death and is otherwise inconsistent with the authorization for its use, the officer may be charged with manslaughter or murder. The bill also has provisions relating to the use of lethal force. Specifically, an officer is prohibited from using lethal force against a person unless the use of lethal force protects the officer or another person from death or serious physical injury. The use of lethal force presents no substantial risk to injury of a third person, and all reasonable alternatives as defined under the bill have been exhausted. The bill also, and I'll be brief about this, contains provisions for duty to intervene and to notify supervisors. Generally, it just requires that an officer must make a reasonable attempt to stop or prevent the use of excessive force if the officer knows or reasonably should know that another officer is using or intends to use excessive force. An officer that knows or reasonably should know that another officer has used excessive force needs to immediately notify the officer's supervisor. The bill provides for medical treatment and also provides for penalties for officers who violate the bill's provisions. Specifically, an officer who recklessly fails to act in accordance with any of the bill's provisions is guilty of a misdemeanor and on conviction is subject to imprisonment not exceeding 5 years. An officer who violates the provisions knowingly and willfully is guilty of a misdemeanor and on conviction subject to imprisonment not exceeding 10 years. There's also provisions for civil actions. Person may file a civil action with a court of competent jurisdiction for use of force by a law enforcement officer in a manner inconsistent with the bill's provisions. The bill also contains provisions for law enforcement agencies. There are specific policy developments that need to be made by local law enforcement agencies. Each local law enforcement agency needs to include funds in its annual budget for training and assessment of training and assessing supervisors in the reinforcement of training objectives in real-world scenarios. By December 31st, 2021, and each 6 months thereafter, each local law enforcement agency needs to post on its public website certain data about the use of force. Moving on, we have Senator Sidnor's bill relating to the duty to report misconduct. That's Senate Bill 166. It establishes that a police officer shall report the conduct of another police officer to the reporting officer supervisor or the chief of the law enforcement agency that employs the reporting police officer whenever the reporting police officer has actual knowledge that another police officer has engaged in specified acts. And those are homicide, the use of excessive force, sexual crimes, theft and related crimes, perjury, fraud and related crimes, tampering with or fabricating physical evidence. And the bill provides that a police officer who violates knowingly and willfully is guilty of a misdemeanor and on conviction is subject to imprisonment not exceeding 5 years, also carries a fine not exceeding $10,000. For Senator West bill, Senate Bill 237, which is public safety law enforcement reform. The bill establishes BPD as a separate instrumentality, or excuse me, as an instrumentality of Baltimore City. It contains provisions for no-knock warrants, and I'm just kind of glossing over these because they're not exactly on point with the use of force discussion today. It provides for training, alters the frequency of training with which the Maryland Police Training and Standards Commission must require in-service level training. It requires that the topics need to be covered annually. Scope of training needs to include training on interacting with individuals with physical, intellectual, developmental, and psychiatric disabilities. Also requires special training, attention to, and study of implicit bias. The bill also has provisions relating to body-worn cameras and requires that on or before October 1st, 2024, each law enforcement agency that employs more than 20 officers shall require the use of body-worn cameras. It provides for an early intervention system, repeals a current provision in law that requires a law enforcement agency to establish a confidential and non-punitive early intervention policy that requires counseling for officers who receive 3 or more citizen complaints within a 12-month period. Instead, each law enforcement agency would be required to establish an early intervention system to identify police officers who are at risk of engaging in the use of excessive force, provide those officers with provide those officers with training, behavioral interventions, reassignments, or other appropriate responses to reduce the risk of use of excessive force. Next, the bill makes certain requirements for the adoption of rules by the chief of a law enforcement agency. A chief under the bill would be required to adopt rules to be followed by all officers employed by the agency. Each officer, these rules are specifically that each officer shall demonstrate the highest regard for the sanctity of human life. An officer may only use objectively reasonable force, that's objectively reasonable, necessary, and proportional force to accomplish the officer's lawful duties. An officer shall, when safe and reasonably possible, use de-escalation techniques to proactively stabilize a situation so that more time, options, and resources may be available to gain voluntary compliance and reduce or eliminate the need to use force. The rules also would need to pertain to intervention. An officer would be required to intervene to prevent or terminate the use of excessive force by another officer, promptly report any incidents in which the officer intervened to prevent or terminate the use of excessive force by another officer. The bill also contains provisions on retaliation. So these policies for each law enforcement agency would need to prevent against retaliation against another officer who reports an incident involving an intervention for the use of excessive force. And it also contains a provision requiring an officer to render aid consistent with the officer's training and when safe and feasible to do so to any person that's in custody with an obvious injury or complaint of an injury. There is a requirement for reporting the use of physical force, using hands-on force, protective instrument, or a canine, reporting for a person in custody that's injured or complains of pain, and reporting of the discharge of a firearm other than in training. The agency rules would also need to cover prohibition on the use of neck holds or other restraining intended to restrict blood or airflow, except in the case of defense against death or serious bodily injury. So turning next to Senator Carter's Senate Bill 50, this is criminal procedure, police officers, and duty to intervene. The bill specifically requires or provides that a police officer who knows or reasonably should know that another police officer is using excessive force or intends to use excessive force shall make a reasonable attempt to intervene to terminate or prevent the officer's or other police officers' use of excessive force. An officer who knowingly and willfully violates this requirement would be guilty of a misdemeanor, subject to an imprisonment not exceeding 5 years or a fine not exceeding $10,000 or both. There is a provision for a civil cause of action. So in addition to the imposition of any penalties, a person who's injured as a result of a violation of this section has a civil cause of action against a police officer who committed the violation. There are training requirements that are required. So MPTSC would need to require for entrance level and service training every 2 years, training on the duty to intervene to terminate or prevent the use of excessive force. Next, Senator Carter's Senate Bill 482, Public Safety, Law Enforcement Officers, Whistleblower Protections. The bill prohibits retaliatory action against a police officer, provides that a supervisor, appointing authority, or head of a law enforcement agency may not threaten or take retaliatory action against an officer who discloses information that the officer reasonably believes evidences abuse of authority, gross mismanagement, or a gross waste of money, or a substantial and specific danger to public health or safety, or a violation of the law. Or following a disclosure as provided by the bill, an officer who seeks a remedy provided under the bill or provided under any other law or policy governing the law enforcement agency. The bill provides that a disclosure that is otherwise confidential or prohibited from disclosure by law needs to be made exclusively to the Attorney General in writing and needs to contain specific information. The bill also provides that a law enforcement agency has a duty to provide an officer with a copy of the subtitle established under the bill in two circumstances. Those being if requested by an officer and if an officer alleges that a retaliatory action has occurred. For this specific requirement, in connection with a civil action brought against a law enforcement agency, an officer aggrieved by a violation of this requirement may be awarded damages in the amount of $5,000 for each violation. An officer in a civil action brought under the bill, so the requirement would be that if a civil action is brought under the bill and a law enforcement officer demonstrates by a preponderance of the evidence that the disclosure of information was a contributing factor in any retaliatory action, that would then shift the burden to the law enforcement agency, and they would need to prove by clear and convincing evidence that the personnel action would have occurred for legitimate reasons, even if the officer had not made the disclosure. An officer may seek, instead of reinstatement and back pay, statutory damages for at least $5,000 for each instance of retaliatory action. In awarding statutory damages, the trier of fact would be required to consider the severity of the prohibited retaliatory action and the purposes of the bill's whistleblower protections. If a trier of fact determines that the officer is entitled to equitable relief, the court may order removal of related detrimental information from the officer's personnel records, may order the agency to reinstate the officer, and may also award the officer compensation for all lost remuneration and reasonable attorney's fees and costs. There are provisions for the instance where a case is brought in bad faith. In this case, the court may award reasonable attorney's fees and other litigation expenses to the law enforcement agency. There are also requirements for the Attorney General. The Attorney General would be required to designate an Assistant Attorney General for the purpose of receiving protected information from officers under the bill, investigating allegations of illegality or impropriety, and taking appropriate action. The bill's provisions would be prospective, and that's just the general summary of the bill. That concludes the presentation.
Excellent. Thank you, Jamie. And so folks, the members of the committee will actually get a copy of this this weekend. So we'll be able to review it, and then all next week we'll be able to talk. We'll have it subject for discussion as we move through our work sessions. So I will say that there is a forthcoming amendment to consolidate the use of force, duty to report, duty to intervene, whistleblower protections. That language will be before you early next week, sometime after our LEOVR work session on Monday. But at least now you have kind of the scope of what has been introduced and is before our committee. And so as we move forward, if members could just kind of, in all the free time that you've got between now and next week, just make sure you familiarize yourself with what's been before us. Again, a forthcoming amendment that will consolidate use of force, duty to intervene, duty to report, and whistleblower protection into one bill for consideration will be before you early next week, so that you'll be able to sift through that language in particular. But in the interim, in the meantime, if you've got ideas or amendments, just please think about them and bring them forward to the committee, to committee counsel, to Jamie. So with that, I'll open it up just for discussion if anyone has anything to say. Otherwise, I just wanted to make sure that we all had kind of the wave tops of what has been introduced and what is likely to be discussed early next week. Looking around, everyone's seems pretty, I know it's the end of the week, so any questions, comments, concerns from the committee? All right, seeing none. Senator Jackson, you are up.
Actually, I was just, actually, Mr. Chairman, I was seeing if that actually worked because the cameras and the microphone did not work initially. So, no, I look forward to getting the packet.
Excellent. So that's right. So Jamie, correct me if I'm wrong. The legislation, so just to be clear again, you reviewed Senator Carter, Senator Sidnor, and Senator, did you have Senator West's, Senator West language will be before us as well. All right. Before you answer that, Jamie, Senator Castley.
Yeah, thank you. Can you hear me all right?
Yes, we can.
So just process-wise, nothing substantive here. Will we have more of an opportunity to hear from a select group of folks from like the chiefs and sheriffs, some of the legal community, both pro-police, pro-defendant, and the like, to work with them on this? What's your proposal on that?
Absolutely, yes. So the next chop is you'll get this. We'll circulate the base language that we're going to be working off of, and then we're going to reconvene again. To get folks, kind of like we had last Friday, a week ago, so we could have more of a work session and work through it. Although, as we discussed, and this is going to be more of a committee-driven process, but it would be great. It's essential to have the stakeholders at the table, but they need something before them to discuss first. So this is kind of just
the way. No, I agree. No, I appreciate that you're putting something out there to discuss, and thanks. I just giving them the opportunity to discuss, I think would be awesome. So we'll just have to make sure they're at the table on that. I mean, clearly the chiefs and sheriffs, and while we state attorneys are certainly important, but I think and OPD and those folks, but I think just as important are, or if not more important, are those lawyers who are very knowledgeable in police misconduct lawsuits and on both sides of the aisle. I think that's very helpful to all of us because that's a critical specialty in all this stuff. So
I couldn't agree more. Absolutely. And just again, the base language is already before you in there's just different vehicles, but the consolidated package will be before you early next week, so that the language is not going to change. So if you want to look at what's already been presented through Senator Carter's bill or Senator Sidnor or Senator West, you can kind of start to work through it. But the consolidated package won't be before you until next week. But the language won't change. All right. Further questions? All right, Jamie, I really appreciate the presentation, and obviously we'll be working. I know that you're working hard. You'll be working over the weekend, so I appreciate that. And thank you so much for everything you've done to this point. Jamie, do you have anything to say?
Sure, Mr. Chairman. I guess some of the bills do actually have different provisions. For example, Senator West's bill requires the adoption of policies by law enforcement agencies relating to use of force, whereas Senator Carter's bill on use of force deals more with the specific prohibitions and requirements. I'm happy to prepare an amendment that consolidates all of that together, but there could be some redundancy or even some conflicting terms.
No, I think what I was using, we'll have a packet. I'll work with you, but we'll have that packet together. And then obviously, for instance, if two items are in conflict, people will have both sides having reviewed everything to consider, but we'll have one package, absent of conflict, absent of duplication, to work off of. And I'm sure that if something wasn't incorporated, people will be able to do that during a work session or a voting session.
Thank you.
Senator Carter.
Hey, thanks, Chairman Smith. Because I agree so much with what Senator Castley said, I just wanted to make sure that we could try to schedule that work group session with those stakeholders and experts, days in advance to make sure that they're available. Because I know a lot of times, people just aren't available. They're not in session as we are.
No, understood. Absolutely. We'll make sure we get it scheduled as soon as possible. Obviously, today's jammed up. We had voting, we had extended floor session, and it's the end of the week. So we'll make sure that we get that on the books early so that the experts and advocates can have enough time to look at what's on the table and to be prepared for an informed discussion. But this is such a broad scope. We need to make sure that you've got at least some sort of, recognition, familiarity with what's been before the committee or what's before the committee right now. So just wanted to make sure that everyone had that opportunity to get the wave tops. All right, with that, thank you, committee. Thank you, Jamie, and have a great weekend. We have an LEOBR work session on Monday. So I'll see you Monday afternoon. Have a good weekend.